Welcome back to Lost Touch Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. As you're well aware, I handle both federal and state cases. And in this video, we're going to talk about two California statutes that deal with domestic violence. And hopefully, after you finish watching this video, you'll understand a little bit better both of these statutes and what your attorney needs to argue to the prosecutor if you're trying to get a better plea deal. In this video, we're discussing two California statutes that deal with domestic violence. It is obviously going to be your decision whether you want to plead guilty or take the case to trial. If you're an individual thinking about taking your case to trial, this video will assist you in understanding how the prosecutor will try to prove the case if he charges you with domestic battery or corporal injury. Now, if you're an individual who is thinking about pleading guilty, this video will help you understand the difference between two statutes, and hopefully through mitigation, your attorney will be able to negotiate one statute versus another. And I'll show you the differences and the benefits of pleading guilty to domestic battery versus corporal injury. So first, let's discuss the elements of each crime. If you go to trial, here's the things that the prosecutor will have to prove. If we're talking about corporal injury, there are four elements to the crime. First, the defendant willfully inflicted a physical injury. Number two, the victim was an intimate or domestic partner with the defendant. Number three, the injury resulted in traumatic condition. And number four, defendant did not act in self-defense or defense of others. Now, if we're talking about domestic battery, the charge is similar. And by the way, I included both sections in the title here. Corporal injury is found under section 273.5 and domestic battery is found under 243E1. If we're talking about domestic battery, there are only three elements. Number one, that the defendant willfully touched the victim in a way that was harmful or offensive. The second element is the same, that the defendant and the victim are intimate or domestic partners. And then finally, the third element is also the same, that the defendant did not act in self-defense or defense of others. Now, in terms of the mens rea, or the mental state of the defendant when he committed this crime, both of these deal with willfully touching or willfully inflicting physical injury. What is willfully? Well, it's willingly or on purpose. So not by accident or not through self-defense like it says here in element number 4. And willfully is the same under both statutes. Now, the difference between corporal injury and domestic battery: under corporal injury, we do need to have this traumatic condition. What are traumatic conditions? We're talking about wounds, bodily injuries. And what are those? Broken bones, bruises, cuts, etc. We're not talking about emotional distress or anxiety. We're really talking about physical conditions. The biggest difference between two statutes is how they're charged and the penalties associated with either one of those. If we're talking about corporal injury, this section is a wobbler, meaning that the prosecutor can charge you as a misdemeanor or as a felony. If we're talking about a misdemeanor, the penalty is 1 year in the county jail and summary probation. And then if we're talking about a felony, then we're talking about 2, 3, 4 scheme years in prison and a formal probation. And of course, if you have priors, the penalties can go higher, meaning if we look at your criminal history and there's some other history of domestic violence, the penalties will go up. In the domestic battery situation, the domestic battery under 243E1 is simply a misdemeanor, meaning that the penalty is 1 year in the county jail, which is the maximum, and summary probation. Of course, your attorney and the prosecutor can agree, or your attorney can later argue at sentencing that the maximum is too much. And in some situations, or in many situations, the judge might not give you any time in jail under misdemeanor. It all depends on the facts, but you will be on that summary probation. So, if you've decided to go to trial, this video now helps you understand the differences between these statutes and what the prosecutor will have to prove at trial. If you've made a decision to plead guilty, urge your attorney to put a good mitigation package to the prosecutor and convince the prosecutor either to go from a felony to a misdemeanor under corporal injury, or even better, go from the misdemeanor corporal injury all the way to the misdemeanor domestic violence. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.